Does a will have to be probated in New Jersey? Probate is a legal process that determines how a deceased person's estate is managed, including distributing assets and settling debts. In New Jersey, this process can be complex, and understanding whether a will must go through probate is essential. If you or a loved one are navigating the probate process, seeking the guidance of an experienced attorney can make all the difference. The Matus Law Group has extensive experience in probate matters and can help you through the legal complexities of estate administration. New Jersey Probate Law. Probate in New Jersey is a court-supervised process that ensures a deceased person's assets are distributed properly. If a person dies with a will, the document is submitted to the surrogate's court in the county where the deceased resided. The court verifies the will's validity, and once approved, the named executor is given legal authority to manage the estate. If no will exists, the court appoints an administrator, typically a close relative, who will distribute the estate according to New Jersey's intestacy laws. Most estates in New Jersey must go through some form of probate unless all assets have designated beneficiaries or joint ownership arrangements. Does a will have to be probated? If a person's estate includes probate assets, property solely in their name without a joint owner or named beneficiary, the will must be probated to legally transfer ownership. Probate assets may include real estate, bank accounts, investments, and personal property. However, not all estates require formal probate. New Jersey allows a simplified process for small estates valued at $50,000 or less if a surviving spouse is the sole heir, or $20,000 or less if other beneficiaries are involved. In these cases, probate may be avoided through a small estate affidavit, which allows assets to be transferred without court intervention. Assets such as life insurance policies, retirement accounts, or bank accounts with designated beneficiaries bypass probate. Similarly, property owned jointly with rights of survivorship automatically transfers to the co-owner without court involvement. The probate process in New Jersey. The probate process begins when the executor files the will with the surrogate's court, along with a certified death certificate. If the court accepts the will as valid, it grants the executor legal authority to handle the estate. The executor's responsibilities include notifying beneficiaries and heirs within 60 days after probate begins, identifying and managing estate assets, including bank accounts, real estate, and personal belongings, paying outstanding debts and taxes before distributing the remaining assets, ensuring proper distribution according to the will's terms or state law if no will exists, closing the estate by submitting final accounting records to the court. If an executor fails to probate a will, beneficiaries may experience delays in receiving their inheritance, and creditors may take legal action to recover unpaid debts. In some cases, the executor could face legal consequences for failing to carry out their duties. Avoiding probate in New Jersey. While probate is often necessary, some strategies can help individuals structure their estate to minimize or avoid it. These include establishing a trust to hold assets and distribute them outside of probate, designating beneficiaries on bank accounts, life insurance policies, and retirement accounts, owning property jointly with rights of survivorship to ensure automatic transfer to the surviving owner. Planning ahead with an attorney can help ensure a smoother transition of assets and avoid potential probate complications. Navigating the probate process can be challenging, but legal assistance can make it more manageable. If you need guidance on estate administration or probate matters, the Matus Law Group is here to help. Contact us at 732-785-4453 or visit our office at 125 Half Mile Road, number 201A, Red Bank, New Jersey, 07701 to discuss your situation.